Well, a good afternoon. Let's get on with this final part of this chat with Professor Richard Leo. Share screen, share sound, share screen, share. There we go. Let's move me out of the way up there. Let's enlarge the screen. It's interesting looking down at the names here: Linda, Sean, Mystic, Neverly. Yep. Okay, dokie. So let's hit on play.
Okay, Mr. Capaldi, it's your turn.
Well, first,
I do have one more question, obviously, and I think everybody knows what that question is.
Absolutely.
So we'll save that one for the end. But
sure. First of all, Dr. Richard Leo and all the guests, thanks for joining in.
It's been brilliant.
Particularly to Richard Leo for replying to my email when I asked you about the false confessions in the 21st century. And now that was the article you did with Stephen Drizzen. Now we, as in the dude and Mark and myself, we went all the way to Melbourne, Australia, believe it or not, to give Steve Drizzen a Brendan Dassey T-shirt about the control question. But what I was wondering is if you could tell us a little bit about your involvement with Steve Drizzen, because he's Chicago and you're California. You know, it seems a long way apart to be working together. But also, you mentioned that you'll be doing another collaboration, looking at
So I've known Steve now for over 20 years. I had gotten my PhD in 1994, and I started studying interrogation and confessions in 1990 when I entered graduate school. I became professor at CU Boulder in 1994, and then I left for the University of California, Irvine in 1997. And I had started publishing articles on my own with Dr. Richard Offshee, a Berkeley professor, now retired. And I think that in the late 90s, this is my memory of it. Steve may have a little bit of a different memory. I think Steve reached out to me. He was a clinical law professor at Northwestern, and he was trying to educate himself on police interrogation and false confessions. I think at that time he might have had a listserv where he was reaching out to a lot of people and disseminating information through large email lists. I remember going to Chicago. I think it was 1999. There was a bill before the Illinois state legislature. I think it was created by a state senator Barack Obama, who nobody had heard of at the time. Sure. And I remember testifying in front of a committee where I met with Steve beforehand, and then we both testified in front of this committee. But actually, come to think of it, there was a conference at Northwestern, a very famous conference in 1998, November of 1998. And I remember I knew Steve then too. So that was the conference put on by Larry Marshall, Northwestern Law School, on the death penalty, where famously a number of people who had been released from death row because of doubts of their innocence came onto the stage and said, my name is, fill in the blank, Kirk Bloodsworth, Gary Galber, etc., Randall Dale Adams. I was sentenced to death by the state of X, and had I not been freed, I would have been executed. Very powerful, very moving. So Steve and I knew each other at least since 1998, possibly earlier, and started collaborating on the article that I think you were referring to, one of them, where in 2004 we had 125 proven false confessions. Now there's 4 ways you can prove a confession false or almost absolutely false. If you can show that no crime occurred, the murder victim shows up alive, for example, but there are other examples. If you could show that it was physically impossible for the perpetrator to have committed the crime, say they were in jail in another state at the time. Right. If you could show there's dispositive physical evidence, often but not entirely DNA evidence that proves they didn't commit the crime, or if the true perpetrator is apprehended, everyone reasonably agrees that person's the true perpetrator. Right. So we found 125 cases like that, and we analyzed patterns in the cases. And the article got a wide reception. It was cited by the Supreme Court in the United States. It's been downloaded many times on SSRN.
Don't use bullet points in a presentation. Look, If you're responsible for driving new sales into a business,
we've been working for years on another article which has 250 proven false confessions. We're almost done with the data coding and analysis, and I need to write that up. So there's been a delay, but that will be a powerful article in the sense that it'll be the biggest sample of proven false confessions. Now, this is different from exonerations. First of all, the National Registry of Exonerations, they use legalistic categories. If somebody's conviction's been reversed and there's some evidence of innocence, though they never specify how much, they put it up there. But all those cases are convictions. Our cases aren't all convictions, and our cases aren't legalistic. We're saying these are cases where we can prove the confession
Right, I understand.
false.
Right.
So it's a different data set. It tells us something different about the criminal justice system and false confessions, although, you know, a lot of the findings might overlap.
Sure.
Steve Drizzen is a great lawyer. He's a great storyteller. He's a good writer. He now has a podcast. He is not a social scientist. I'm a social scientist. I'm not a great storyteller. I don't have a podcast. So we are complementary. You know, so we form a good working relationship, I think, because we bring different strengths to the table.
Right. I love Professor Drizzen. And we went all the way to Melbourne so that this guy down here, Dr. Leo, could shout at Professor Drizzen that he wasn't Welsh. It was quite an experience.
But he wasn't what?
That he wasn't Welsh.
He called me Welsh. From Wales. I'm from Scotland.
Anyway, I want Scottish whiskey. I don't want a T-shirt. I want Scottish whiskey.
Yes. Yeah.
I got some McCallum here. You have to drive down to LA though.
I've got some Singleton.
Anyway, so yeah, that was a good time though. But so that brings us to the last question, and obviously this is the question everybody's probably been waiting for, because they know I never shut up about this, and it's the fact that in Brendan's interview, there's the point where Tom Fassbender asks Brendan what he calls the control question. And at this point, he makes up a fact about a tattoo being on Teresa's stomach that didn't actually exist. And he tells Brendan, we know Teresa had a tattoo on her stomach. Do you know about that? And at first, Brendan says, which would be kind of what Tom Fassbender wanted. He would have wanted Brendan to deny it, and that would have made the control question a success. But unfortunately, Tom Fassbender goes one step further because for whatever reason, I guess he wasn't satisfied with the and wanted something a little more. And he says, do you disagree with me when I say that? And the moment he says that, he gets Brendan's hackles up. And so, so to speak, because Brendan immediately, with the psychological coercion that's been going on in my mind, immediately goes, oh God, I don't want to be disagreeing. And he basically is like, he tells him no. He says, so by saying no, I don't disagree with you, I'm agreeing that she had a tattoo she didn't have. And Tom Fassbender and even Judge Hamilton at the Seventh Circuit Court pointed to this as proof that this was proof of the fact that Brendan's confession was valid. And I'm sitting here going, no, this is proof that Brendan was buckling, just like we've been telling you he was buckling and bending to the will of these investigators. I wanted to get your thoughts on that a little bit, if you have any.
I mean, that's, first of all, the control question idea comes from the polygraph.
Right.
There's no such control question technique in any interrogation. So it's a garbage idea that was invented by Fassbender here. Also, if you were going to test for held back knowledge to see if the person knew a non-public detail not likely guessed by chance, you wouldn't create a question where you could guess 50%. She has a tattoo, she doesn't have a tattoo. So it's a garbage question. And then third, he apparently guessed it right. She didn't have a tattoo, which you would expect from an innocent person. And fourth, as you say, he was pressured into coming up with the desired answer when Fassbender did the follow-up question. So the whole thing just illustrates, I think, the interrogatory incompetence of Fassbender and the completely worthless evidentiary value of Brendan's answers to that question.
Yes, and also in that first part of that, when he said, "Do you know whether Teresa had the tattoo?" He said, "No." That's not a statement that she didn't have one. That's a statement that he didn't know, right? That's a different answer, let alone the subsequent thing, which actually just shows that he was buckling.
Well, and it was a bad question. It wasn't set up right for Brendan to understand it anyway.
Exactly.
No, that's very true, Zelma. Yeah, yeah.
Right. No forensic interviewer would have asked a question like that.
Not without getting in some trouble.
And the double negative in the second part of the question is like always going to confuse someone like that.
Oh,
So,
sure. Yeah.
So
It's that's why I try to explain it to people in that way where I go, Tom Fassbender is saying, do you agree with me? Or do you disagree with me? And when he says no, he's essentially agreeing. And you know, it is always hard to get people's head around that, but so does anybody else have any other questions? Let me look over and see if anybody in the chat has asked. I see a lot of people.
I just want to know what we can do. I mean, what can be done at this point?
You mean for Brendan Dassey, right?
Yeah.
Or even, other kids like him.
Anyone in that situation.
Well, I mean, Brendan Dassey, I thought you were asking about his case, like, Lauren Ryder, maybe you've had her on your show. She would say, what she's doing behind the scenes in terms of the governor's office or if there's any litigation possibilities. But obviously his case is very far along. It's sad. There's a Democratic governor. Anybody with a brain should see that he should be released and either given a new trial or just, not harassed or hassled anymore by the system. I guess when you're saying anybody, what you mean is how can we prevent people from being interrogated such they would make false confessions like Brendan and then be wrongfully convicted and incarcerated for life? And there's a lot of answers to that question, none of which are perfect. Mandatory recording from start to finish, better training, you suggested, I think, judges and police interrogators and prosecutors and defense attorneys, everybody, about juveniles, about false confessions, about police interrogation. Maybe we have some requirement that police are not allowed to interrogate unless they show they have a quantum of meaningful evidence, because there was none in Brendan's case. They just imagined it. And so they went at it. So if you don't have probable cause or reasonable suspicion, you can't interrogate. Maybe we don't allow certain techniques like lies about evidence, for example, or maybe we lower the bar for suppression. If there is contamination, we throw it out. Or maybe we do what I wrote about in that 2013 Law Review article with Peter Neufeld and Steve Drizzen, and make judges using evidentiary law more aggressive gatekeepers of whether confession evidence comes in or doesn't come in. Maybe we only allow juveniles to be interviewed by trained forensic interviewers, not by police, not interrogated on tape, right? Maybe we have cautionary jury instructions always. Maybe we always allow expert witness testimony, right? So there's a range of policy, legal and policy suggestions that we could implement to prevent this from ever happening again. The challenge is when you're
Is there a disconnect between how fast you imagine yourself ripping across the fretboard and how fast you can actually play? Well,
when you're not sitting in a room or on a Zoom screen where everybody thinks alike, is when you have somebody pushing back saying, but there are going to be guilty people who go free, and how do we balance the benefit to the innocent against the cost society endures for the guilty? And so I think it's a deeper policy discussion, but I don't think any of those suggestions are going to let many, if any, guilty people go free.
But when it comes down to it, these are the discussions that need to take place, even if there are going to be people, as you say, out there pushing back. But these are the conversations that need to take place.
Right. So policy, legal and policy solutions that will prevent the next Brendan Dassey.
Right. Absolutely.
Yes, because a lot of the things that we're talking about, sorry, Dr. Sultan, one of the things we're talking about is is the issue of behavior. And when there is ill intent, all the rules and regulations get thrown out, and best practice gets thrown out when you have ill intent, which we would argue is what's gone on here. That is the ill intent to make Brendan collateral damage in the pursuit of Stephen Avery. Now, if we have rules and regulations, there should be consequences for those who breach them. These are public officials. And the fact that most of these people get nothing done to them when they do things wrong, in other words, this immunity issue, is something that should go hand in glove with that array of things that you just mentioned, Dr. Leo.
Right. There is a movement in the United States. Excuse me. There is a movement in the United States to end qualified immunity in light of the
George Floyd.
the killing of George Floyd. Yeah. At least a lot of intellectuals and people in the media and some politicians are talking about it, but it's not clear whether that's going to actually happen.
I mean, I think at least they need to lower the bar a little bit. I think there's a number of things that they might consider doing, but it looks like they're not considering doing anything. So,
but I agree, there should be consequences. There definitely needs to be consequences for rule violations.
I agree.
For causing innocent people to not only falsely confess, but also to be wrongly convicted.
I mean, that's how we learn, right? When we're kids, we learn not to reach our hand in the fire because it burns our hand. And when it's unpleasant when that happens, we don't like that. So therefore we don't reach into the fire again. That's the way that's supposed to work, right? And so if these folks have no consequences, they have nothing to stop them from going, off the chart or off the beaten path, you might say, I guess. But yeah, so well, I think that's about it. Except, oh no, Dr. Silver, sorry.
Can I make one comment? Just one comment.
Yes.
First of all, fantastic discussion. But Professor Leo, I read your affidavit, and your analysis of the Reed technique means that if law enforcement officers continue using the Reed technique, individuals like Brendan Dassey, of that ilk, of that mold, of that type, are going to continue being found guilty of crimes that they never committed because of all their deficiencies. So therefore, why is it that a lot of the states in the United States are now abandoning the Reed technique and adopting, I think, the peace technique? Why are there some states still persisting with the Reed technique, knowing full well that certain individuals are going to fall through the crack, like Brendan Dassey?
Well, I don't think, and I hope I'm wrong, that the peace technique is widespread in the United States.
I don't think it is yet either.
I'd like to see it more widespread. So I hope that I'm wrong. I think that police are very skeptical that the Reed method or their methods cause false confessions.
Right.
They often deny that false confessions occur, or acknowledge in the abstract that they do occur, but they themselves have never gotten any false confessions, or that it's a minuscule problem, like somebody getting killed by a bee sting. And so by trivializing or ignoring the problem, they don't see any need to fix the Reed method. And some of them believe that guilty people will not confess, and therefore the Reed method is justified, even if it sometimes leads to false confessions. Lander and Zulawski, the famous firm that broke off from Reed and Associates in the 70s, I believe, they repudiated the Reed method. But they do, if I understand correctly, mostly private, corporate security type investigations. I'm sure they train some police, but they are not, as I understand it, police themselves. There's no study that I'm aware of that surveys police departments to find out if they do the Reed method or they don't. Oftentimes, police in America will deny they use the Reed method, even though they do. Either by Reed and they forgot, or they've been trained by somebody who is training them in the Reed method, but they don't know it's called the Reed method.
Oh, right.
How we enact this cultural change and get them away from the guilt presumptive, accusatory, confession driven, minimizing approach that we call the Reed method. I don't know the long-term solution. It's a changing police culture. It takes a lot to change police culture, and police interrogation is one of the least visible aspects of what police do. When we think of policing, we don't always, especially now in America, we don't always think about interrogation. So there's no real interest group that's lobbying for this change, and police don't see the problem internally. If they saw the problem, right? If there was a video of somebody who died in custody after being interrogated for 9 minutes, maybe, and then there were mass protests, maybe we'd be having a different conversation.
Or if there were consequences for their behavior, be they sanctions or admonishment or even, losing their employment, they don't have any consequences for acting in that way.
Correct.
And therein lies the problem. They need to be self-regulated by the consequential aspects of what they do.
I mean, they would say that the evidence is thrown out if they don't comply with the rules and they want the evidence to come in. But you're saying, I think there's no personal consequences to them.
No, and if they act unprofessionally and the evidence gets thrown out against a person they, interrogating or believe is a suspect because they were incompetent or lack diligence, then one of the consequences for them is the fact that they'll be regarded as being poor at their profession, let alone any other more sort of draconian consequences. And at the moment, there isn't any. And I just think therein lies the base problem. You can teach them all you like, but people like Erekose said, they put their hand in the fire, they feel that it hurts, and they go, you know what, I'm not going to do that again. And therein lies the solution, I believe.
I agree.
Yeah. So, Nothing But a Stump is asking, and I think he kind of touched on this, but let's go ahead and have him answer it. Rhonda wants to know what your opinion is of the Reed technique versus the peace technique and which one you prefer.
Well, I far prefer the peace technique. It's investigative interviewing. It's about getting the truth. It doesn't presume guilt. It doesn't use heavy-handed interrogation tactics. It's evidence-based. It doesn't involve deception. It's far less likely to be coercive. It's not designed to be coercive. As best I understand the studies in places that use this kind of investigative interviewing, particularly England, there is not a decline in confessions. Of course, there's a lot of cultural differences between England and the United States. So, yeah, I think it's a no-brainer. I would like to see a system that dissolves or gets rid of the Reed technique and replaces it with, whether we call it peace or just investigative interviewing, non-accusatory, truth and information-driven investigative interviewing, as opposed to accusatory, guilt presumptive, psychologically deceptive, manipulative, and sometimes coercive confession-driven interrogation, which is what the Reed method is.
Right.
Yes.
And one other person asks, I guess they want to hear your thoughts about the fact that Fallon, in closing arguments at Brendan's trial, said innocent people don't confess. Last thing the jury hears before they go into deliberations.
Well, that's intellectually Neanderthal. I mean, people said that in 1932, and that started the wrongful conviction field. Nobody would say that now. That's just embarrassing that anybody would say that. In the era of DNA, the first DNA exonerations, and arguably the very first one, David Vasquez, involved a false confession. There's some dispute about whether it was David Vasquez or someone else who was the first. But there, as you pointed out, there have been hundreds of DNA exonerations, and no sane, rational person would say innocent people don't falsely confess. It's just a lie. Especially
Fallon. Especially someone like Fallon.
Yeah, somebody like him would definitely know better. So, all righty. Well, I want to thank you very much for being here, Dr. Leo. It's been an absolute pleasure, very informative. It's been very interesting to hear your point of view on all these things. And I'm sure everybody else here feels the same, right?
Very much so.
Okay.
Thank you so much.
So can I just finish off just by saying, obviously, thank you for joining us.
Yes.
Could I just mention we haven't had Laura Nyrider on the show yet, but if you could put a good word in for us, we would greatly appreciate that.
Well,
I will do that. What is the name of your show? Is it I Stand with Brendan Dassey, or is it something else?
my channel on YouTube is called Erekose on Making a Murderer.
All right. All right.
Yeah.
I will put in a word to Laura Nereiter, and I think she'd be perfect for your show. And
Yeah.
I also
Thank you.
want to thank all of you. I've enjoyed this, and I've learned from it, and I hope our paths cross again. And keep up the good work. We all want to see Brendan get out.
Thank you.
Yep.
Absolutely.
Yes, we
Thank
do.
you. And we want to see changes in wrongful convictions in general and the way that they're handled. So,
Absolutely.
So thank you
Absolutely.
again. Hope you guys all enjoyed it out there. You know the drill. If you haven't already, please hit subscribe, and we'll see you.
Good day or good night to everyone. Thank you so much.
As it applies.
Thank you.
Bye.
Right.
Well, there we go. And bizarrely, I didn't actually get around to asking the crunch question, which is most bizarre because I normally do. Flummox the guests at the end with that particular question. Also, what I found interesting was he mentioned the big conference they had, Northwestern, to do with where they brought in people who had been sentenced to death and who had then been exonerated, found to be innocent. And if the death penalty had been enforced, then of course they would not be around to to come to that conference. They just wouldn't be around. And it reminded me of the Anthony Porter, Our Story Simon, Murder in the Park. And I just checked the date on that. And indeed, Tony Porter was released within 24 hours of being executed in 1999. So that does seem to have tied in with that conference, which Dr. Leo referred to about early on in that fourth part. Anyway, it was great to have Richard Leo on the show. So far, our efforts to get hold of Laura have not been successful. But in fairness, she's probably busy doing so many other things. They've not just got Brendan to have to try and work his case. Anyway, hope you enjoyed that final part, and we'll have a look at another of the Classic Dude videos in the not too distant future. Thanks for tuning in. Bye for now.